Good morning, my friends. Today I'm presenting to you a very interesting case adjudicated by the Honorable Calcutta High Court, that is Asian Switchgear Private Limited versus the State Tax Officer. The issue is you are alleged of an offence under GST. Against that offence, you are submitting your reply, but the GST department is not considering your reply before giving out its judgment. Is this not a violation of the principles of natural justice? Dear friends, against the allegation by the GST department, you want to put up your defense. But the department is not willing to consider your defense before slapping a penalty of 200% on you. Is this not a violation of the principles of natural justice? Yes, this is exactly the case and the issue which arose in front of the Calcutta High Court. So let me put forth the facts of the case before you. Asian Switchgear Private Limited, its vehicle was taking some goods and was in transit along with a proper valid e-way bill. Raste mein, during in transit, the vehicle broke down. So the driver moved the goods from this old vehicle to a new vehicle and along with the old e-way bill again started the movement. Everything was the same, just the e-way bill was the old bill. On the way, the vehicle was intercepted and detained by the GST authorities. When the vehicle was detained, they checked the e-way bill. During the checking of the e-way bill, they found the vehicle was not the same. When the vehicle was not the same, they detained the vehicle and imposed a penalty of 200% under section 129(3) of the CGST Act. Friends, at this point, the SSC submitted its reply and contention to the adjudicating authorities that it was a mistake which was unintentional and there was no intention to evade tax at all. This was beyond the control of any human being. But the tax authorities were just not willing to listen to the contention of the SSC. They did not release the vehicle. So the SSC had no choice but to pay the penalty in order to get the vehicle released. SSC had to pay the penalty of 200% in order to get the vehicle released. And the second thing to be done is to go for an appeal in the High Court. Friends, in order to go for an appeal in the High Court, the SSC has to pay a pre-deposit of 25% in order to go for an appeal. So left with no choice, the SSC appealed in the High Court. The Honorable Calcutta High Court gave a proper hearing to both the sides, to the Asian Switchgear Private Limited and the GST department. After completely hearing the facts of the case, the Honorable High Court came to a conclusion that this was a genuine case and it was not a mistake on the side of the SSC. The vehicle broke down in transit and this was beyond the control of a businessman. And the GST department imposing the penalty, and that too under section 129(3) of the CGST Act, and that too alleging the intention to evade tax, was absolutely not right. And the Honorable Calcutta High Court vacated the penalty, and rightly so. The Calcutta High Court vacated the penalty order of 200% on the SSC. And the SSC was relieved and they got their vehicle and the goods back. So friends, this was a mistake of the e-way bill. And many times we see such mistakes keep happening because when the vehicle is in transit, there can be a breakdown, there can be the e-way bill gets expired, there can be a mismatch in the date, there can be a mismatch in the vehicle number, and there can be such mistakes which do happen. At that time, my humble submission to the GST department is that the proper officer have to listen and take cognizance of the fact. Of course, there are genuine cases where there is an intention to evade fraud. At that time, the proper officer can and should make use of his good powers and take charge of the situation by taking things under control. But on the other hand, there are also such cases which are genuine and which are no intention to evade tax. So in such cases, there was no need to impose such a big penalty of 200%. Had the proper officer heard the SSE properly, he could have used his good judgment and understood what the entire situation of the case is. In this particular case, it was a clear violation of the principles of natural justice. Friends, I hope you enjoyed listening to this case study. Stay tuned for more such legal, informative and interesting case studies. Please subscribe, like and share. See you all again very soon. Until then, thank you.